The legal system seems to be one of the hardest facets of society for people to imagine privatized. If there are multiple competing courts, for example, people might ask, why would anybody accept the verdict of a court that they don't happen to agree with? What's going to stop them from seeking a second or third or fourth opinion, and so on and so forth? And prisons are an even harder, concept for people to understand. For example, how can punishment be made into a voluntary decision? They'll say, I personally think that the problem with this line of thinking is that it preserves the exact form of our legal system as it currently exists and simply changes these forms from the forceful monopoly that we currently have to multiple competing agencies. And while I do consider this to be an improvement, I don't think it addresses the central issue, which would be the actual form, the shape that exists of our legal system. So instead of being sent to an institution against one's will for a predetermined amount of time in order to rehabilitate that person, there are in fact other approaches to preserving social order and security, as well as justice, that don't rely on the simple get arrested, get held in jail for a while, speak to a judge, get found guilty, then go from that jail to prison process. And that's basically what I want to ask you about at this time. That is, how can courts, police, and prison be privatized exactly? And how would external punishment work if we're speaking in a voluntarist society?
Well, and opinions vary upon that, even among libertarians. I think the reason most ordinary people have a tough time understanding how a private legal system would work, partly is because of the rise of legislation in the last 100 years. And, 500 years ago, 1,000 years ago, 300 years ago, people thought of law as more of a scientific working out of the principles of justice by courts in response to disputes between people, where the judges were trying to do justice between the parties and find the best result, to minimize conflict and to respect the developed legal principles that people have been relying upon so far. But when legislation started becoming more and more of a dominant way of so-called making law in the last 100 years, which happened after the rise of democracy and the rise of the administrative state, at this point, and especially in America with the Constitution, so people start thinking of laws as not what is not being discovered by judges and being compatible with kind of our nature and what's naturally fair, but it's just whatever the government decrees, right? So so they think of laws as things that are written down and announced by some committee, like a legislature or a parliament, or the founding fathers, when they wrote the Constitution. This is just something written down. So people start thinking of law as words written down and issued by the sovereign, which is the state. And then these rules have no necessary connection to justice. And in fact, they have less connection to justice because they're arbitrary. Whether you can drive over a speed limit, or what the age of majority is, or whether it's a crime or not to have practice certain religion or read certain books, or use pornography, engage in gambling, consume drugs or sell drugs, that kind of thing. So over time, people start losing. They don't think of law as having much to do with justice. It's just what the government decrees. That's why. And then this reasoning also is similar to that of many, even some minarchists who believe in minarchy, and like objectivists. A lot of them actually ideally believe in a one world government. Like the idea of having 200 separate jurisdictions in the world drives them nuts because it's not uniform. So logically, they should favor one world government because that's the only way to have an objective law across the whole world. Most people don't believe about having a one world government, even your average citizen. So they understand that there can be disputes between people in different countries, even though there's not a single legal system. So they understand that there's some higher law or international law or customary law or treaty law or contracts between people. So they understand that you don't have to have one legal system. So we just say, let's decentralize even further. Let's have 50 states, which we do in the U.S., maybe go by county, maybe go down to the individual level, maybe go by contract alone. If you got rid of the idea that law has to be issued by a legislature, it would be easier for people to assume to understand that law can develop in a common law system, in a decentralized, evolved legal system, and that it could be different from region to region or country to country. If we decriminalize so many things that have no basis being criminalized now, like get rid of the drug war, for example. Don't have don't make certain things. Only make illegal what is a natural, what we call a malum in se crime, like basically only trespass against people's property and their bodies. Murder, rape, theft, trespass. Only make those things illegal. Respect property rights as defined by contractual arrangements and contractual transfers. That's the core of what a legal system would do. And if you did that, there'd be the jails would be 95% empty right away. Now there is disagreement among libertarians about whether we should have a criminal system at all, or whether we should get rid of the criminal system, and have everything be handled by tort and by restitution. I tend to think that myself, almost the other way, though. I think that we should get rid of all non-criminal law and everything is criminal law. That is, the whole purpose of law is to settle disputes and to determine who the owner of a resource is. And in the case of a crime, that means someone has violated the borders of someone's owned resource, and the victim now has some response that they are entitled to, some kind of punishment or some kind of restitution. My personal view is that there is as I argue in my book, in I think chapter 5, my estoppel theory, I think that when someone commits an act of aggression, violent aggression, like an act of murder or serious assault and battery, that they have forfeited part of their rights to complain about being punished. So I think in principle, punishment is justified. But I think in practice, it would be very, very rarely resorted to in society in an institutionalized way, for reasons that the more pacifist and the more anti-punishment types have pointed out, like say Randy Barnett in his book The Structure of Liberty and other theorists, because punishment, number one, is very expensive because you have to have a high burden of proof, and if you're wrong, then whoever does the punishment is now liable for harming the rights of the victim, of the innocent victim who was punished wrongly. And it doesn't actually help the victim of a crime to punish the aggressor. It's better if they get some kind of restitution, and if the aggressor has a way to apologize, make amends, make some kind of compensation or restitution to the victim, and work their way back into society. That would keep them from having to go to prisons. And if someone refuses to cooperate, then I think ostracism and being unable to participate in the benefits of being in society would be a strong way to handle crime. Now, and again, we're imagining a more peaceful society because it's already going to be a more libertarian society. So there's be far fewer crimes because most people would not voluntarily be willing to commit crimes, and we'd be richer, so there'd be less need to commit crime, and there'd be fewer actual crimes on the books because all these fake crimes would be taken off the books.